We are in a verdict watch. It's California versus Kellen Winslow II. Day 5, 20+ hours. Now, the jury is out to lunch right now, but we are not. So let's bring in our friend, the most dashing attorney in the state of California, criminal defense attorney Brian Claypool. Brian, it's day 5. We are approaching 21 hours, my friend. What's happening?
Well, the jury deliberation is heating up just as we are facing a mini heat wave. Isn't that ironic? It's really hot out here at the courthouse. In fact, I drove in here 10 miles inland to get here to the courthouse. See, it was almost 100 degrees there. So I don't know if this jury has something to do with the weather now here in San Diego. But look, I think we've got to face a reality that there's some of these jurors are deadlocked with other jurors. I think Chanley and Julia did a great job for your viewers of explaining the mannerisms of the jury. That's really, really telling in this case. And I think either later today or sometime tomorrow, you're probably going to get a note that that the jurors are having trouble reaching verdicts. And I think you're then going to face the issue of what's called an Allen charge, which you've heard about in cases all across the country, that the judge is going to have to deal with.
Okay, Brian, but I would have expected the deadlock note on Friday, not on Monday. But yes, I think that's a great point. And for our viewers, Allen charge basically means the judge is going to say, okay, you got to go back there and try again. Because it's rare that just one note saying we cannot agree on all the charges lends itself to declaring a hung jury. So that's what we're expecting. Now, Brian, I think it's time that we look back at what the prosecution said that they were going to deliver. Did they deliver? I'm sure you're a fan. Remember this song, Naked Eyes, Promises, Promises, You Make Me, Promises, Promises. Let's roll this. Did the prosecution deliver on its promises, BC?
Well, Seema, I'm glad you asked, because I think where the prosecution might have fallen a little bit short, especially in closing argument, was really humanizing Jane Doe 1 through 5. I was in there for closing argument, and in a case where it's hinging a lot on credibility, I think the prosecution needed to do two things in this case. Really humanize these victims, number one, and then give the jury some kind of plausible explanation as to why many of the victims had trouble with recollection. Remember, we dealt with that, like they were wrong on inconsistencies on what they observed, possibly lying about certain things. But I think in closing, I would have talked more about the victims, like Jane Doe number 1, the troubled life she's lived, the homelessness, the paranoia, the Jane Doe 2 dealing with similar issues, that these are young women on the street and they're fighting to survive every day, and they should be given the same credence as anybody else. And then Jane Doe number 4, she's a teenager at the time. Now she's married with a family. Why would she come in here and tell you a lie? I felt like that was missing a bit in closing, and then I really felt like the big gorilla in the room, based on that question Friday too. Hey, what does under oath mean? Well, obviously the jury's asking. Somebody's asking because they're trying to minimize all of these inconsistencies that we've heard. We needed a better explanation. Why would all these victims come up with different versions of what happened or have inconsistencies? And I just don't feel like there was enough of that explained to the jury from the prosecution standpoint. And that's why we're at a logjam now.
Do you think the under oath question, though, was because the jurors were trying to suss out which statements were made under oath, for instance, in a pretrial hearing, and which statements were just a result of an interview, for instance, to law enforcement?
No, I don't think that's it. What I think is you've got a handful of jurors in there, and I think it's predominantly the women that Julia talked about, who are probably in that deliberation room with at least 2 or 3 of the men that you've done a great job of describing today, and the discussion is going something like this: well, wait a minute, that comment about not drinking, that's not a big deal, or that comment by Jane Doe 2 about you know, she wasn't menstruating. You know what? That wasn't under oath, or that's not that big of a inconsistency. And then the gentlemen are probably saying, wait a minute, that's under oath. And if that's under oath, then they're lying, and you've got to find an acquittal. And that's what probably led to, all right, let's find out. You know, what is the exact definition of being under oath? And that mirrors what Chanley said. Juror number 12 was, I think, was nodding his head when the judge was reading that definition. I mean, that's telling. That suggests that he's saying yes to the other female jurors, not yes to the judge.
Right, and as we know, we have no idea how many jurors are asking for what in that note. It could just be one, it could be a few of them. We have no idea the way to predict. But, okay, so do you think we're going to get another note today? What's happening today? I want your prediction. You're out there. You know what's happening out there.
Yeah, I think you're going to get another note by the end of the day, and it's going to say, hey, look, we're having trouble reaching a verdict. And the key thing here, here's an interesting issue for you, Seema. Will the jury be able to reach a verdict on some of the counts and not others? Because that's what Judge Bauman will have to go back to them and say, hey, look, I don't know what you're hung up on, but you know, if you're hung up on one or two of the verdicts, you got to still, you know, work on the other ones for a verdict. So this is not an all or nothing proposition. That's a really interesting point to talk about, which is, do you think that the fraction in the jury, that the jurors in each camp are able to break up their verdicts? In other words, find guilty on Jane Doe 1, but maybe not guilty on Jane Doe 2. I think that's going to be a real problem for some of these jurors.
And that, BC, is what we like to call splitting the baby, and we will revisit it. But right now, we got to take a quick break. We are still on a verdict watch, my friends. Keep it here. Well, defense attorney Brian Claypool still with us live at the San Diego courthouse. So, Brian, let's talk about that complicated jury instruction, which in essence says if the jury finds beyond a reasonable doubt the charges with respect to Jane Doe number 2, they can use that as a factor in deciding the charges with respect to Jane Doe number 1. Is this why Dan Owens started his closing argument talking about Jane Doe number 2?
Seema, can I ask a big favor? Please, please. Can I comment a little bit on this note that you were talking about that the jury circulated on Friday?
I feel like it's a free-for-all with you, Brian Claypool. Okay? Sure. Let's. As long as my producer doesn't cut me off, then she says go for it. We say go for it.
All right. Look, I think that Dan Owen should have asked the judge. He's the prosecutor. He should have asked Judge Bauman to interview the jurors after that kind of note. Because Vinny's right, that is a rogue juror. You have a note from the jury saying, we've got concern over one of the jurors, let's read between the lines, who's not going to follow the law. So that's going to create contamination within that jury room if there is a juror that's not willing to follow the law. And I think that what should have been done is the prosecutor needs to move the court to then interview the jurors, put it on record, find out which juror is doing that, and try to cleanse the process. And here's another problem then. That hasn't been done yet. And just so your viewers know, the judge just can't unilaterally do that. He needs somebody to make a move and tell him to do that. But let's say we now get a verdict. And then there is a verdict. There's now potential for what's called juror misconduct, because after this case is concluded in California, lawyers can approach jurors. They can call them up. They can hire private investigators. Unless the juror says, absolutely, I don't want to talk to you, it's fair game. And you can go interview jurors, get affidavits, in other words, sworn statements from jurors saying, hey, juror number 5 was saying this in the jury room about not wanting to follow the law. Boy, if that surfaces after there's a verdict, I guarantee you the verdict will be set aside for what's called juror misconduct. And that's why they should cleanse the process now.
Okay, Brian Claypool, I am not done with you because I want to know if you're just jumping on the Vinny Politan bandwagon or we have a legitimate argument here. So stick around. We've got more Court TV Live after this. Folks, we're on a verdict watch. Okay, let's go back out to Brian Claypool, who is live at the San Diego courthouse. He's a criminal defense attorney, and he's a purveyor of justice and knows all. So, Brian, let's get back to that really complicated jury instruction with respect to Jane Doe number 2 and Jane Doe number 1, because okay, so the instruction basically says, as Owens explains, if the jurors find beyond a reasonable doubt the charges with respect to Jane Doe number 2, they can use that as a factor in deciding the charges with respect to Jane Doe number 1. And as all of us observed, some would argue that Jane Doe number 1 was a difficult prosecution witness. She wasn't that emotional. She was combative. She made plenty of inconsistent statements. Is this jury instruction a backdoor way of getting some credibility for Jane Doe number 1 by using Jane Doe number 2?
Yeah, it's a great point. I would phrase it more as a Hail Mary. I mean, that's why when I first met you 2-3 weeks ago, I was kind of befuddled about why Mr. Owen was having all the victims, prosecuted in one trial, and then now it's become more clear. He needed some of the other victims with that jury instruction you just mentioned to try to get a guilty verdict on Jane Doe number 1. He probably knew that he had a problem with the credibility and the inconsistencies of Jane Doe number 1. But look, at the end of the day, it's a fascinating jury instruction, isn't it? I was in the courtroom when Dan Owen read that, and I have to say, I was like, wow. You could use, if you find guilt on some of these victims, you could use that. And I think he mentioned it had to be clear and convincing evidence. It's not even beyond a reasonable doubt with that jury instruction.
Well, actually, originally,
it's a fascinating instruction.
I think originally we thought it was going to be preponderance of the evidence, but I think it is beyond a reasonable doubt with respect to Jane Doe number 2. And then, your point is by clear and convincing evidence for Jane Doe number 1. Is that what your point is?
Right, correct. Yeah,
right,
exactly,
okay.
Right. He made that clarification in closing argument.
Is the use of this instruction fundamentally fair? Because let's just remind the viewers all the potential reasonable doubts with Jane Doe number 1. She had 5 arrests for public intoxication, and this was the time period, I believe, it was... I think 2009 to 2019. I know it was the most recent 5 arrests. There was conflicting statements about her alcoholism. The daughter says she was an alcoholic. She said she wasn't. There was the investigator, Sesma, for the defense, showed that she was within seconds of several establishments that she could have gotten away from Winslow, by a sushi restaurant, a 24-hour fitness, as well as a Vons, that while she was on one side of the fence, Winslow was on the other side of the fence. She could have left at that point. Her daughter got to testify, but her daughter wasn't actually there at the incident. And the daughter's observations about the white pants, again, what was on those white pants? There was a reddish-brown stain. Still, there were several times where Jane Doe number 1 said she went back and forth between menstruating to gushing blood as a result of a violent sexual assault. And she had told, Jane Doe number 1 told Detective Benavides that she didn't know if she felt threatened. And of course, we've reminded the viewers over and over again about this crucial point that Jane Doe number 1 did not pick Winslow out of a photographic lineup. She did not pick Winslow out at the pretrial hearing, and she didn't identify him in court. So there are all of these doubts, these actual doubts with respect to Jane Doe number 1. But this jury instruction, doesn't it send a message to the jury and almost to the public saying, hey, it doesn't matter because we have this instruction, so you can use Jane Doe number 2, which happened later in time. So that's the other question of fairness is Jane Doe number 2 occurred on Mother's Day 2018. Jane Doe number 1 occurred on St. Patrick's Day 2018. Jane Doe number 1 wasn't cooperating with the police. They lost touch with her. And then only after Jane Doe number 2, they backtracked and secured this indictment for Jane Doe number 1. So let's look at the system, Brian, and I'm concerned that using this instruction is a demonstration of unfairness in our system.
Right. That's a good point, because usually in a criminal trial, to me this is almost like what's called prior bad acts evidence, and we all know that most of the time, especially in sexual assault cases, unless the defendant has allegedly committed almost exactly the similar kind of alleged rape. Remember the Bill Cosby trial, where he seemed to have the same exact protocol with all of these alleged victims? That wasn't the case with Kellen Winslow. So to me, this instruction is kind of a backdoor way to get in prior bad acts evidence that the prosecution would not have otherwise been able to get in for the reasons you've just described. So it is, in my opinion, unfair. But the good news is this: we have criminal trials that include cross-examination, that include instructions on credibility of witness. And remember, this evidence is what's called predisposition evidence. And if I was Mr. Carlos, I might have done a better job, or a firmer job, of explaining this instruction to the jury and say, hey, wait a minute, and say what you just said. Hey, wait a minute, this is a backdoor attempt. Don't fall for it. You don't have to find guilt on Jane Doe 1. It's just predisposition evidence. It's meaningless, and here's why: because of all these inconsistencies with Jane Doe number 1.
Brian, we'll leave it there right now.
It can be buffered in closing argument.
We'll get you back in the next hour. Our Verdict Watch continues. More Court TV at the top of the hour. Let me go to Brian Claypool for some insider's perspective and a quick comment on this latest information that we have received a 4th note, which says, in essence, as of 1:55 p.m., that specific time, the jury has a decision on 4 out of 12 counts. This note is set to be read 3 p.m. Pacific, 6 p.m. Eastern. So Brian Claypool, as someone who practices in that area, someone who knows the judge and who's watched every moment of these proceedings, what do you make of this note that says, hey, we have a decision on 4 out of 12 counts, and there's nothing else on the note?
Right. I mean, we shouldn't be surprised by that, given the note on Friday, right?
Yeah.
But what the judge has to do is clarify, either do one of two things: either send a note back to the jury and clarify, does this mean you are at an impasse on the other 8 counts? Or the judge could opt to do this, a second option, which I think he's going to do, which is send a note back and say, please continue to deliberate on the remaining 8 counts. Because right now, we're just implying, I guess it's implied within that note that the jury has reached an impasse. But again, we need to create a court record, and there needs to be a record as to whether the jury is in fact at an impasse.
Yeah, I don't think the judge should use that word impasse, because it's too suggestive. I think he should say, just go back and keep deliberating, and thanks for the update. Okay, Brian Claypool live at the San Diego courthouse. We are on a verdict watch, folks, and we are waiting for the 4th note from this jury. More Court TV live after the break. This note says the jury's come to a decision on 4 to the 12 counts. Brian Claypool, is it possible that this note is just day 5? Brian Claypool, day 5, 21 hours, and this is where we're at? Just a verdict as to 1 Jane Doe? That's all we've gotten?
Yeah, that's completely plausible. And, you know, based on the note you received on Friday, based on the wonderful coverage from Chanley and Julia today about the mannerisms of the jury, describing the jury, this is not a surprise. And this is a defense lawyer's best dream to get a note like this. Let's make no mistake about it. I mean, this is favorable to the defense when you've got 12 counts and only 4 they're deciding on.
Okay, but Brian, I mean, again, this is purely conjecture, because there's just so much back and forth with this jury, at least from what our team has seen, because they break off into factions. There's juror number 12 who sits in the hall by himself, sometimes doesn't eat, just sitting there, not reading, not looking at his phone, not doing anything. So you know, it's conjecture. But okay, so Jane Doe number 5, just a misdemeanor, 4 counts. Going by, again, this note, because let's just remind the viewers again, last week we heard readback from Jane Doe number 4 and her friend Nicole Edwards. So we heard essentially 2 large portions of readback with respect to Jane Doe number 4. Okay, so hear me out. Jane Doe number 4, there are 2 counts. Jane Doe number 2, there are 2 counts. So it is possible when the jury says we have reached a verdict on 4 out of the 12 counts, they could have reached a verdict on Jane Doe 2 and 4, and they could be hung up on Jane Doe number 1 because Jane Doe number 1 was the most controversial alleged victim.
Yeah, I respect your theory, but I don't think that's going to be how it plays out because of how divided this jury is. In particular, I think juror number 12 we had talked about. So I just don't see juror number 12 and 2 of the other gentlemen, for example, finding guilty on 2 and then not guilty on 4, and I don't see the women. Similarly, I don't see the women then that we had discussed earlier today. The group of women, ruling one way on 2 and then one way on 4. I just don't see it happening. I think this is whoever came up with the 4 counts on 5. I think that's really where we're going, and I think the biggest thing here we've got to decide, the judges have to decide, is sending a firm note back, like you said earlier, that the jury needs to continue to deliberate. And what's interesting for your viewers is we're not going to find out which counts the jury has decided on. The judge can't send a note back saying, hey, which 4 are they?
Someday.
That's not going to happen.
Someday, Brian Claypool, we hope to find out. Maybe not today, maybe not tonight, but someday we are going to find out the answers. Okay, let me just ask you, you think that the women on this jury would vote the same way for Jane Doe's 1 and 2? Is that what you said?
Yeah. I just don't see the women on this jury. Why do I think?
Yeah. Why
do I think they wouldn't? Yeah. Well, because of the way they're behaving during the jury deliberation, because of the theme that's been driven in this case about the prosecutor. Remember how many times? 21 times, I believe he said. Kellen Winslow Jr. is a sexual predator. I just don't see them parsing out, oh, he was a sexual predator as to Jane Doe 1, but he's not a sexual predator as to 2. And you made a good point that helps my point now earlier, which is you can remember what you said about you can use evidence of 2. Yeah, exactly. I mean that's powerful. I just don't see the women parsing this out. I think it's an all or nothing proposition with the women. The women jurors that we've talked about are either all in for guilty or they're not, and that's the way it's going to play out. That's just my prediction here. I don't see it being parsed out.
Okay, all right, so hold on. They send out this note. It says, jury has come to a decision on 4 out of the 12 counts. So you're on board with the Court TV theory that, or some of the people here think, there's a verdict as to counts 9 to 12, and those are the 4 counts with respect to Jane Doe number 5. Where do you think the jury is then with Jane Doe 1, 2, 3, and 4?
Right. I think the men that we've discussed, you did a great job earlier. 2 of them are in the airline business. 1 was in airline tech. They're more analytical. Those are good jurors for the defense in a case like this. You talked about juror 12, a retired military veteran, another good juror for the defense in a case like this. And that poses a problem for the prosecution. I don't see those men finding guilty on Jane Doe 1 and 2 for sure. I've already stated why throughout my appearances on your show. Those are easier for them to find not guilty. Jane Doe 4 was the one that I thought that would be the best chance for a guilty verdict. And then look what happened. We had a readback on 4, and then Nikki, I think, is it Nikki Summers?
Yeah, Edwards.
A readback with her.
Yeah.
Or Nikki Edwards, and then you get that question about, under oath or not, and the inconsistencies with that. And
So,
I
okay,
think
Brian,
that was the final straw.
I gotta get in Julia Janae, but your bottom line is you think they're divided with 1, 2, 3, and 4, and they're only in agreement on 5. Is that your bottom line?
That's my bottom line.
Okay,
Absolutely.
I'm gonna catch you after a break.
It'll be hung on those too.
Okay, well, hey, don't use the H word. Okay, we'll catch you after the break. Brian Claypool, do you think it's possible that the judge will read this note in open court and then immediately say to the jury, okay, go back in the room and decide what you're gonna do about the other 8 counts that you haven't addressed in this note, continue to deliberate?
Absolutely, but before he does that, he'll get the views of both the prosecutor and the defense counsel, put that on the record. Maybe if you're the defense counsel, you object. You say, hey, look, they've been, like you said, they've been deliberating 5 days. It's over. We only want the 4 counts, and that's it. That's got to be put on the record, and then the judge will make a decision on his own, which will be what you said. He'll tell the jury, go back, continue to deliberate on those other 8 counts.
Okay, Vinnie Politan, they have not even addressed the other 8 counts. There's no way this judge can just say, okay, we'll just accept the 4 and have a nice day. Thanks for your service.
No, I think he has to send him back to continue to try until he gets another note saying that we're deadlocked. You know, it's interesting, you talk about 8 counts here, and the one thing that we talked about in the beginning was there's a lot of opportunity here for negotiation and compromise by the jury. So if you have one camp that's on one side, another camp on another side, you've got 8 counts that you can negotiate over. And sometimes juries do that. Someone will give in on one count if you give me on another count. And because there's so many Jane Does, so many counts, that's a possibility, but what I'm hearing right now is that jury is not doing that.
Okay, wait, do you think it's possible? Because, and I'm looking at the list of counts, there are 2 counts with respect to Jane Doe 2. There are 2 counts with Jane Doe 4. Is it possible that the 4 counts they're referring to is 2 and 4, and they're undecided on Jane Doe number 1, who has 3 counts, number 3, who has 1 count, and number 5, who has 4 counts?
Absolutely, and the reason being that they've gone through this. There's been so much time that they've deliberated that they could have gone through every count, right? And they have. Presumably they have gone through every count, and they could have found the ones that people they really truly believe, and where they believe the evidence is strong. It could be any sort of combination of that. I've seen partial verdicts before. Sometimes they make sense, sometimes they don't.
Right, and even in between the charges, we could just have like one of, they could be guilty for the kidnapping, but not guilty for the forcible rape. Brian Claypool, do you think it is important that this judge instructs the jury in a very vague way? Because he doesn't want to be at fault for pushing them to write a deadlock note or pushing them to say anything else, right? Because they have no clue. We have no clue as to what counts they're talking about, what counts they've come to a decision on.
Yeah, exactly. And you made a good point in the last segment, which is that the judge can't be suggestive in any manner in how he instructs the jury. And he needs to be 100% crystal clear, because even Vinnie made a good point, which is we haven't heard from the jury that they are at an impasse. So the judge simply needs to say, great, got your note, let's get back at it. And he's got to have really a positive attitude right now. Please continue in your deliberations on the other 8 counts.
Even Vinnie made a good point, and that's why Vinnie's going to get the last word. Brian Claypool, thank you so much. Vinnie, what can we look forward to tonight besides the reading of this note?
This is it. I think tonight's the night, right? One way or the other. The jury still has time to deliberate. The judge sends it back out, and they still have time to send another note saying, you know what, Judge, we can't reach a decision on these other 8 counts. So we are waiting to hear what happens at the top of the hour, and then from there, we'll see the rest of the way the rest of the night plays out. But anything is possible at this point.
We could be in a verdict watch late tonight,
yes,
or maybe even until tomorrow. Thank you so much, Vinnie Politan. Court TV's breaking news coverage continues after this.